Alex here with part 172 of the My Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of this series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off with, I think it was 2 videos back, with the motion for order to show cause. We are now going into my ex's attorney's opposition to our motion for order to show cause. I don't think my mindset at this time would have been any more frustrated than it already was. We have an attorney who is, most of their case is gaslighting. They're acting like what they're asking for is reasonable. They're acting like what we're asking for is not. They're acting like the legal doctrines that we're bringing up don't make any sense. And it's a very, very heavy gaslighting tactic. It's very common, guys. If you see attorneys that do this, don't think you're the only one that they're doing it to. I've mentioned before, it's highly effective, and I talk about why they do it in the video. Win at all costs. If you want to learn more, please watch the video Win at all costs, and you'll see why that comes into play. Also, I think what factors into their style being, I think this is going to also go into a little bit wing it lawyers and wing it judges. These are 2 different videos that discuss why these tactics are more effective in family court than they are in other types of courts. This attorney, I imagine, is going to be doing the same thing now in his opposition to motion. He's going to be acting like his client's conduct makes sense. We're the weird ones. We don't make any sense. And I'm guessing that that's the best he can do, because that's the best that he has. And I talk about that in the video. They will never say good things. They're not just going to go and admit that they're wrong and tell the court, everything that the other person's saying is reasonable. They're going to have to do something. They're going to have to find some way to make it plausible that their conduct is justified and to make you look like unreasonable or like a crazy person. All of this, I'm assuming, is going to come up in this opposition to motion. It's what I have seen from this attorney the whole time through. And it's what I'm assuming I'm going to see going forward. Now that we're actually at this point in the video, I think there isn't anything else to mention. So let's just go ahead and take a look at what this attorney has filed. So, that's going to calm things down after the fact, but it still doesn't help, because I'm sure that there are many, many examples where this will occur and the attorney will succeed. I think with all of that being said, we need to actually go ahead and take a look at what my ex's attorney has filed. Here we have the opposition to motion for order to show cause, standard introductory paragraph indicating that he is representing my ex. He's her counsel of record. And points and authorities. Okay, so he starts off with indicating or recognizing that my ex owes a multitude of arrearages. The next document, or the next paragraph, is that she only had to pay, that she also has to pay a monthly child support amount in the amount of $571.57. Goes into the law on contempt, which we've already discussed before, guys. Contempt is NRS 22.010 with regards to its definition, and then there's another statute that covers its penalty. Dispositional orders have to be entered in writing. This is something that I've discussed before. You can't hold somebody in contempt unless there's an order in writing. This is a really curious perspective, though, because the 8th Judicial District Court has a court rule that allows you to hold somebody in contempt when they violate an oral pronouncement from the bench, which is odd. But we'll talk about that more. I don't even know if it's going to come up in the series, because this entire case was litigated in District 2. But yeah, I very much agree with this precedent that says you can only be held in contempt for violating a written order. Yet I just want to warn you guys that there are other districts out there in Nevada and probably in other states that will, at least they say that they can hold you in contempt for violating an oral pronouncement from the bench even prior to the entry of the written order. Okay, let's see here. The inability of the contemptor to obey their court order is a complete defense and is sufficient to purge of them of the contempt. This is true. If you are not able to comply with the court's order, you can purge yourself of the contempt. It's very true. Next, we have the Supreme Court's distinguishment of civil versus criminal contempt. Contempt that is designed to punish versus contempt that is designed to coerce conduct. I'm not going to talk about this a lot, guys, because I have a video that's dedicated to this topic and I cover it in very much detail. Please watch the video on the topic contempt of court if you want to know more about the distinction between civil and criminal contempt, because it does matter. Allegations related to the $50 payments. I'm claiming that my ex made her court-ordered payments of $50. Initially, my ex attempted to comply with the court's order by sending checks, and they were rejected. This is because we tried to execute on the judgment. So he's using this against us. He's trying to say that because we didn't accept those payments and we tried to execute on the judgments, that she's not in violation of the court order because she doesn't think she has to pay those $50 payments now, which is a ludicrous statement, but that's what he's going to say because he's her attorney. Next here, and that's basically how he's going to cover the $50 payments. He's just going to say that she didn't know that she was in non-compliance and that she's sending five $50 payments now. Child support arrearages. So she's failed to pay $1,453 in child support. She's saying that her child support obligation was subject to wage withholding and that she's under the impression that her child support would be taken from her paychecks. She's going to try this in the courtroom when we get to the hearing, and the judge isn't going to find it to be very cute. So you're going to get more of this argument in the courtroom when we go to a hearing. She's just going to get blasted for non-compliance with payment of child support. It's true that the Child Support Enforcement Division takes some of the money from her check, but they don't take all of it from her check. So the attorney is trying to say that she has no control over how much the district attorney's office withholds, and that since she has no control over it, that it's not her fault that she's not paying child support. Again, the judge is not going to be amused with this argument. I'm conceding that we are to split transportation costs, and I'm admitting that there are additional transportation costs that need to be offset, and the amount has to be determined. So she's not going to contest that she owes child support that wasn't taken from her checks. However, the deficiency is not a result of a sinister plan, nice word, on her part to deprive me of child support. Rather, she simply expected her wages to be garnished. So, I mean, if he's going to take this position, okay, here it is. He concedes that she owes money that wasn't taken out of her check and proposes that she pays the funds as outlined below. Okay, and then we have uncovered medical expenses that are coming up. Let's see here. So he's conceding that medical expenses are coming up. And then he is claiming, or he's saying that I claim that she has failed to reimburse for uncovered medical expenses that have come up. Monica's right as a custodian was violated. So he's trying to say that we violated her rights because she wasn't informed of an appointment. He's actually, I don't know if he realizes what he's doing here, but he's actually just arguing the same things that she argued at that hearing that didn't work. So he's saying that she didn't have a say in the appointment and that her legal custody of rights were violated and that she's entitled to notice and an opportunity to weigh in on any not. So he's trying to say the same thing, that she has a right to weigh in on these expenses and that since she didn't weigh in on them, she doesn't have to pay them, something like that. She wasn't given an opportunity to be part of the conversation. So this is horrible. I don't think he realizes that she's using the same arguments to basically try and get out of paying these costs. And the judge doesn't find this cute either. So this is going to blow up on her at that hearing too, I suspect. I can't remember this one as well, but when he goes to court, I think he thinks that he's raising new arguments and he doesn't realize that he's just saying the same things that my ex was saying at that hearing, and it makes him look really bad. Okay, so this stuff right here, guys, isn't really very legal, so I'm going to skip through it. But this whole section here is him just saying that he's admitting that she needs to pay this money and she wants to come up with a way to pay the money. So paragraphs and paragraphs of how she's going to pay these child support amounts and these medical arrearage amounts. Conclusion is that she's not in violation of the court's order on purpose. She's in violation of the court's order on accident, and that there's no sinister plan, those are his words, for her to violate the court's order. So he's saying since she accidentally violated the court's order, she shouldn't be held in contempt of court, and that he's going to find a way to get her to pay these monies. Spoiler alert, guys, she doesn't pay this money. She doesn't pay it. Eventually, this attorney is going to retreat. He's going to withdraw from the case because he can't control his client, and it's going to take him a while to realize that she's a knucklehead. But in that small amount of time, he's going to basically make himself look really bad. Here's the affirmation pursuant to the law, indicating that this document doesn't contain a social security number. Here's a certificate of service indicating that this was mailed to my attorney. And here is the motion opposition notice indicating that he did not have to pay a filing fee with this document. We have some exhibits here. We have 1, 2, 3 letters. Okay, letter number 1. This is the same. Okay, we've already gone over this letter. Same check. We've already gone over it. We've gone over this too. These are the bills that we've gone over all of this stuff. Here's another check for $50. Okay, these are old exhibits. They're just pasting the same exhibits. It looks like this is new. What is this? Money order for $50. Money order for $50. 3 money orders. Hey guys, I think these are the money orders that we never got. She never sent us these. This comes up at the hearing. If you want to know just how bad a high conflict X will, obviously she created these money orders. This is true. But these money orders were never sent to us. And so what she did was she issued these money orders and then she just destroyed them or she threw them away. Because in her mind, she was more willing to actually pay this money but not give it to us than she was to pay this money and give it to us. It satisfied something for her. This is going to come up at the hearing, and I'm going to talk about it more when it does come up at the hearing. But this money was just destroyed. It's like, and it's not that crazy, because if you think about it, from their perspective, they can't control the fact that they have to pay the money. This has to occur. But they can control the fact that they don't give you the money. And the court's not going to find it plausible that somebody issued money orders but didn't send them, because the court's not going to understand the mental health issues that a high conflict X has. The court's going to think, why would somebody create all these money orders and just throw them away? That doesn't make any sense. They may as well send them to you, because that way your child will get money. But the court doesn't understand that they really don't care about their kids. And so for us, it's like, yeah, duh, of course she did that. But for the judge and the lawyers, they're like, that sounds so weird. There's no way they would do that, because I wouldn't do that. And there's just this disconnect between the courts, the attorneys, and the actual high conflict X. I talk about this in the video, High Conflict Incompetence. It's highly recommended that you watch that video, because it's going to give you the perspective and the misguided opinions or directives that the courts have with regards to high conflict cases. They just don't know what they're doing. And so I talk about that in the video, High Conflict Incompetence. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex's attorney filed the opposition to motion, and that's a free filing, so they incurred $0 in costs. I had an attorney who helped me for free, so I incurred $0 in attorney fees. My ex's attorney, well, they put a substantial amount of work in that opposition. I'm hesitant to say that it would be more than an hour's worth of work, though. Most of the law is copy-paste. And most of the facts asserted, he's already asserted in the other filings anyway. So he's relying pretty heavily on those other filings. The only thing that's new is the discussion on those new medical arrearages. I don't know, maybe 1 hour is too low, because there would have been some back and forth. There would have been some discussion. They would have had to have gotten those bills. So I guess an hour and a half would be more reasonable. At the rate of $250 an hour, that's going to come to $375 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post those questions down in the comments below, and I will see you guys next time.